Welcome to Swayam online course on Public Financial Administration. In today's module, we'll be discussing on the legislative procedure in the Parliament. You might wonder why legislative procedure in the Parliament. As far as public financial administration is concerned, it is connected to public administration, and we know that for a procedure to be enacted, it has to be passed through the rule-making body. There are three main organs as far as governance is concerned. One is the legislature, which is the rule-making body. Second is the executive, and the third is the judiciary, taking care and upholding the law of the land. And the judiciary, it plays a very important role as far as guarding the constitution is concerned. The executive, on the other hand, is protecting and also implementing the programs passed by the rule-making body. So, the three organs of a government should be working interconnectedly and also should be in the same wavelength so that the program is successful and governance is accomplished to the fullest. So, it is important to understand the legislative procedure. As you know, the Constitution is such an elaborate and long procedure. It's a long book, one of the longest written books across the globe. And it is imperative to know that to pass a bill, be it a finance bill, be it a money bill, or an ordinary bill, what are the procedures to be followed. So, if you look into this model, I have constructed such a way that you will see what are the procedures followed for passing a bill and making a bill an act. So, if you see, the legislative procedure is identical in both the houses of the Parliament, that is, the lower house, which is the Lok Sabha, and the higher house, which is the Rajya Sabha. So, both the houses, the lower house, the Lok Sabha, and the higher house, which is the Rajya Sabha, follows more or less the same principles as far as passing a bill is concerned. So, it has many stages, and when we see that a bill has to pass through each stage, we need to also understand what will the bill be. A bill is a proposal for legislation and becomes an act or law when duly enacted. So, it becomes a law and act when it is duly enacted by the legislators themselves. So, you know that the legislature has people representing the constituency. So, it is the will of the people and the needs of the people in the form of a bill being produced to the legislature, and the rule-making body can pass the bill in the form of a law or an act, and it becomes enacted on the assent of the President of India. Bills introduced in the Parliament are of two kinds. One is the public bills and the other is known as the private bills, also known as, otherwise known as government bills and private bills on the corporate needs. So, the two bills which we understand will be the private bill and the public bill. The bills introduced in the Parliament can also be classified into four categories. So, you know there are two types of bills. One is the public bill, the other one is the private bill. Now, there are four types of bills that can be passed. One is the ordinary bills, the other one is the money bills, the third one is financial bills, and the fourth is the constitution bills. Ordinary bills. What is ordinary bills? It's a concern with any matter other than financial subjects. Anything other than financial bills can be considered as an ordinary bill. Now, money bill. Money bill is concerned with financial matters like taxation, public expenditure, anything to do with taxation where you have to incur money from the public, then it becomes a money bill. Public expenditure, expenditure for the needs of the public becomes also a money bill. Then you have the third bill is a financial bill. The financial bill is also concerned with the financial matters, but it is not concerned like the money bill of taxation. So, it is different from the money bill. Finally, you have the Constitution amendment bills, which are concerned with the amendment of the provisions of the Constitution, making a change in the Constitution provisions itself. We will be having an exclusive model for the amendment of the Constitution bills itself. Now, to understand the four categories which we have discussed, the ordinary bill, the money bill, the financial bill and the Constitution amendment bills. First, we need to understand what is a constitution or an ordinary bill. The Constitution has laid two separate procedures for the enactment of the four bills. The procedures regarding to ordinary bills, money bills and financial bills are the three bills which we will explain, and the Constitution bills also will be explained exclusively. Now, the ordinary bills. Every ordinary bill has to pass through the following 5 stages in the Parliament. We are now talking about the ordinary bill which has to go through 5 stages. Let us see that what are the 5 stages, and it is necessary to see that the statute mentions that the 5 stages are as follows. First, reading. First is the reading. There are 3 readings actually apart from the 5 stages which we are talking. The first reading. An ordinary bill can be introduced in either house of the Parliament. It is not like the money bill or the finance bill. The money bill will have to be presented only by the Lok Sabha. Here it can be presented from either house of the Parliament, either from the Lok Sabha or either from the Rajya Sabha. Such a bill can be introduced either by a minister or by any other member. The member who wants to introduce the bill has to ask the leave of the house. Okay? So, ordinary bill will have a first reading as the first point for the enactment, okay? And it can be passed both in the Lok Sabha or in the Rajya Sabha. And what the minister has to do, has to get permission to introduce the bill as a leave of the house. And then when the house grants leave to introduce the bill, the mover of the bill introduces by reading its title and also its objectives. No discussion on the bill, you should remember that no discussion of the bill will take place at this stage. So, first reading is only would be about asking permission. So, you see in an ordinary bill, you can go either from the Parliament, either house of the Parliament, that is from the Lok Sabha or the Rajya Sabha, and you also notice that it can be given by a minister of either house of the Parliament, and you have to get permission for the enactment of the bill. But the first step is only getting a permission and in the form of the leave of the house. And when getting the leave of the house, he gets the permission to introduce the bill. But at this stage, there is no kind of discussion going on about the bill. Now, you see that later the bill is published in the Gazette of India. If the bill is published in the Gazette, before the introduction, leave of the house to introduce the bill, it is not necessary. Okay? So, you should remember, if a bill is published in the Gazette, before its introduction or leave of the house to introduce the bill is not necessary. The introduction of the bill and the publication of the Gazette constitute the first reading of the bill. So, this is known as the first reading of an ordinary bill. Okay? So, we should also reiterate again, we have 5 stages for introducing the bill. The first is called the ordinary bill, and in the first stage what happens is it can be passed either house of the Parliament, either by the Lok Sabha or by the Rajya Sabha, and you should know that when you need to present a bill, you should get the leave of the House, and on getting the permission, it won't be discussed, but it will be only introduction of the bill. And you must also remember that there will not be any discussion, but it can be published in the Gazette. So, these two things can happen simultaneously, and this constitutes the first reading of the ordinary bill. Okay. So, you should also know the difference between a public bill and a private bill at this juncture, because this also constitute the ordinary bill. Now, what is the difference? It is introduced in the parliament by a minister as far as a public bill is concerned. On the other hand, it is introduced by any member of the parliament other than the minister. The private bill can be introduced by any member of the parliament from both the houses, and it can be introduced as a representation, that is it, but the minister will be representing a public bill. The second point is it reflects the policies of the government. Anything to do with the policies of the government will become especially the ruling party, it becomes a public bill. On the other hand, the private bill, it reflects the stand of the opposition and also the voice of the public. Okay, anything to do with public matter, a concern, it can be introduced in the parliament other than the minister himself. So, it becomes a private bill. The third point is it has a greater chance to be approved by the parliament, because it is a public bill and it is a government requirement and it has come from a ruling party. So, they have seen the concerns, and it would be imperative that the parliament can pass, and especially if the parliament has a majority of the ruling party, then easily it is passed. On the other hand, if you see, it has a lesser chances of a private bill, but if it is a concern which would only enhance the ruling party, then perhaps it can be passed. The fourth point is its rejection by the House amounts to the expression of the want of parliamentary confidence in the government and may lead to also resignation. So, when a public bill is presented, although it looks very easy that it can be passed by parliament, it can also be subjected for resignation of the ruling party. So, it has to be accepted, and if it is subjected for passing of a no confidence motion, then the parliament can go for a no confidence motion and can lead for dethroning the ruling party. So, there is certain odds as far as the public bills is concerned. So, it should be really scrutinized, but it is not as in depth as it is in the British Parliament, where the bill is not passed and immediately the party will have to resign. Here also it can be subject to no confidence, and the party might lose its majority and it's also its ruling authority. In the other hand, its rejection by the House has no implication on the parliamentary confidence and also by the government or its resignation. So, being an opposition is much easier in passing a bill, because when a private bill can come, any number of private bills can come as far as the opposition is concerned, or any member of the parliament can present it and it can be subjected to the needs of the requirement, and it can be rejected also. So, it does not bound to any kind of no confidence motion, and there is no fear of no confidence motion or resignation or dejection. Finally, its introduction in the House requires 7 days notice. Okay? It requires 7 days notice, and also its introduction in the House requires at least 1 month's notice. Difference between the private and the public bill is, in the public bill you need 7 days notice, as far as the private bill is concerned you need nearly 1 month notice. So, you can understand very clearly as far as the public bill and the private bill is concerned. So, we are discussing now on the ordinary bill. So, ordinary bill could be a public bill or a private bill. Public bill is usually presented by the minister, and the private bill can be presented by any other person other than the minister, but is a member of the parliament. Usually the opposition or any other member who may be supporting the ruling party, but not may be part of the ruling party. But it becomes a public bill when the government plans to subject itself for a public bill so that it can be presented and passed to be acted because of the need of the hour. But it can be subjected to no confidence motion if the bill is rejected by the majority in the parliament. And finally, it needs 7 days of notice, whereas a private bill requires 1 month of notice. Now, it is also drafted by the concerned department in consultation with the law and department. So, law department plays an important role because they have to see whether the constitutionality of the bill is maintained. As far as the private bill is concerned, its drafting, the responsibility goes to the member itself. So, here and there they are affording to make some mistake, but here they cannot make that mistake because it has to go through the law department. Now, we know what is an ordinary bill. The first reading of the ordinary bill is very clear, and the difference between a public bill and a private bill. Now, we go to the second stage, which is a second reading. What is a second reading? During this stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. So, you see in the first stage only the introduction of the bill, recommending to introduce the bill. The second stage goes in depth, that is a detailed scrutiny, and also assumes its final shape. It also forms an important stage in the enactment of a bill. In fact, this stage, second stage itself, has 3 more substages, which is namely a general discussion to go into the intricacies, the details of the bill itself, and also the committee stage, and finally the consideration stage. So, a general discussion, a committee stage, and a consideration stage. So, these are the 3 parameters in the second reading, because you have to really look into the need and the necessity of passing the bill. So, this is a responsibility of the rule making body. So, the rule making body is responsible for a good law or a bill to be passed as an act. Now, the next stage, the stage of general discussion. We have to discuss in detail what happens in the second reading. The printed copies of the bills are distributed amongst all the members. So, everyone should have a hard copy of the bill that has to be passed, and the principles of the bill and its provisions are discussed generally, but the details of the bills are not discussed. Basically, a framework. The framework will be discussed and then it will be presented to the members in the form of a hard copy. At this stage, the House can take any one of the 4 factors. One is, it may take the bill into consideration immediately or on some other fixed date. Okay? It depends on the urgency of the matter. It can happen immediately, or they can give a fixed date and say that this can happen on this day, we can have a discussion, but if it is not urgent. The second point is, it may refer the bill to a select committee of the House. It can refer to a select committee, form a committee and say, okay, this committee will check into the matter to see whether it is imperative. The third point is, it refers the bill to a joint committee of both the houses. So, if they think that the bill cannot be just scrutinized by a selected committee in the lower house or the upper house, it can be formed, or it can recommend a committee as a joint committee of both the houses. The next point is, it may circulate the bill to elicit public opinion, to get feelers from the public opinion. Nowadays there is a lot of social media, so the feelers will come from the social media. Now we know that we have been discussing on the 33% of women in the parliament bill to be passed, and we can see how public opinion elicits a response, and also the government realizes that it is necessary to have 33% of representation, because we see that despite being very progressive, the number is not being achieved as far as representation of gender is concerned. So, a select committee will consist of members of the house where the bill has originated. So, if it has come from the Rajya Sabha, you will have members from the Rajya Sabha. At the same time, a joint committee consists of members from the both houses of the parliament. Okay? So, you see that the first ordinary bill, we have a first reading, which is just an introduction and displaying it in the Gazette. The second reading will have few stages, and in those stages, the first primary stage is a stage of general discussion, and under general discussion, you need to see that where does the bill come from. If the bill comes from one particular house, then you should have members representing from that house, or it can have a joint session from representatives from both the houses, that is upper house and the lower house. And also they have to fix a date as per the requirement and as per the urgency. And also the main important thing is it can elicit public opinion if they have to respond immediately. Now, we have already seen that there is a stage of general discussion. Now, we have a committee stage. As far as the committee stage is concerned, the usual practice is to refer the bill to a select committee of the house. The committee examines the bill thoroughly and go into details, clause by clause it is checked, and then it can also amend its provisions. After amending its provisions and making its final report or recommendation based on the principles underlying it and seeing whether there is constitutionality, after completing the scrutiny and discussion, the select committee reports the bill back to the house. So, this is the role of the committee stage. Okay, so you see the one is a general discussion, then it is decided it will be given to a committee, then the committee will scrutinize. After committee scrutinize, will give its response based on the principles which is attached to the bill, and whether it is abiding to the constitution, then the committee stage will respond back to the parliament, to whichever house it was presented. Then you have the consideration stage. In the consideration stage, the house, after receiving the bill from the select committee, considers the provisions of the bill, clause by clause. It will again reconsider every point which is suggested by the committee stage, and each clause is discussed and voted upon separately. So, it is gone and defragmented, and it is made into a step by step ceremonious practice of passing a bill. So, it does not happen just like that a bill which has been introduced can be passed. It goes through various stages, and in the second stage itself you see that there are various practices. First will be a just discussion, committee scrutiny, then consideration scrutiny, and finally the amendments will be made if it has to be passed and accepted, and then that becomes a bill. And then finally it moves to the third stage, which is the third reading stage. So, see, from the first stage to the second stage will have a few stages which will be consideration, and then finally it goes to the third reading stage. In the third reading stage, the debate starts. It is confined to the acceptance or the rejection of the bill. Whether the bill will be accepted or rejected as a whole will be accepted, or if there are no amendments to be made, then it can be taken as it is. If the general principles underlying the bill have already been scrutinized by the second stage, because second reading goes in depth clause by clause. And if the majority of the people present at that particular moment or on the fixed date have no problems at all, and voting accepting the bill can be done. So, what happens is, once the bill has gone through the process of the first reading and the second reading, it goes to the process of the third reading. Okay, the third reading will be the stage where they will have to put it to vote, because if the scrutiny has been done by the select committee, then there no need to even scrutinize clause by clause, but can be voted. If a majority of the members present and voting accept the bill will be regarded as passed by the House, okay, whichever House, and thereafter what happens is the bill is authenticated by the presiding officer of the House, and like how you say that I recommend and I second it, it is authenticated by the presiding officer and transmitted to the second House of the Parliament. So, if it is passed in the lower house, say the Lok Sabha, then it is passed to the Rajya Sabha for passing the bill, and for consideration and approval, a bill is deemed to be passed by the Parliament only when both the houses have agreed to it, either of the house or without amendments. Okay? So, it can be with amendments or without amendments, either of the fact, but it has to be passed by both houses of the Parliament as far as the ordinary bill is concerned. The next point is the bill in the second house. Now, you have now seen that the 3 readings has been done. The select committee has checked through the committee stage and also gone into a consideration stage, and now the bill has been passed by that concerned house. Now, it goes to the second house for consideration. In the second house also, the bill passes through all the 3 stages: first reading, second reading, and also the third reading. The same procedure is followed in the second house, and there are 4 alternatives before this house. What are the 4 alternatives? First, it may pass the bill as sent by the first house. They have agreed that everything is fine without amendments, then it can be passed. It may pass the bill with amendments and return it to the first house for reconsideration. Okay, if they see that okay, this could be a problem, then that can be tuned and changed, and amendments can be made and be sent to the next house. The third, it may reject the bill altogether. Finally, it may take into action any of the bill which has been pending, So, it may not take any action and thus keeping the bill pending. So, you see that there are 4 aspects. The first aspect is it may just pass the bill as it is. Second, it may make an amendment. Third, it has to follow the procedures of all the stages which has gone in the previous house, and also the bill can make a rejection altogether as far as the house is concerned. And finally, if it may permit it not to take any action and thus keep the bill pending. If the second house passes the bill without any amendments, or first house accepts the amendments suggested by the second house, the bill is deemed to have been passed by both the house of the Parliament. So, if you see the first 2 stages, that is passing the bill as it is or passing the bill with amendments, it can be accepted by both the house of the Parliament. But if you see that it is only pending with the President's assent. On the other hand, if the first house rejects the amendments suggested by the second house, or the second house rejects or keeps it pending or does not take any action for 6 months, a deadlock is seen to have taken place. Okay? So, to resolve such a deadlock, the President can summon a joint session of the 2 houses. Can say that both the houses can come together to take a call. If the majority of the members present and also voting takes place in a joint session approves the bill, the bill is deemed to have been passed by both the houses. Okay? So, you see how the ordinary bill can be passed as a bill. Now, it can be passed either by the lower house or the upper house. It can be passed and moved to the second house. The second house can deem it necessary to pass the bill as it is or make changes and send it back for reconsideration. At the same time, they can also reject the bill. So, when the President sees that the bill has been rejected, then he can convene a session for both the houses, a joint session, and call for a voting. When majority of the members are present, then they call for voting and pass the bill. It can be deemed as passed. Now, assent of the President is the fifth stage. Every bill after being passed by both the houses of Parliament, either singly or jointly sitting, is present or presented to the President for making it an act. Okay? And his assent is necessary. Why it is necessary? Because it is necessary that the President has to give his assent to make a bill, an act or a law. It may also consider to give his assent, one point, or he may withhold his assent to reconsider, or he may return the bill for reconsideration of both the houses if he thinks it is not right at that particular moment. So, he can hold. It is like the veto power. It does not have a veto power. So, it is not a veto power exactly, but it has a power to withhold for reconsideration. If the President gives his assent to the bill becomes an act and is placed in the statute book. On the other hand, if the President withholds his assent to the bill and the bill ends and does not become an act. Okay? And also if the President returns the bill for reconsideration and if it is passed by both the houses of the Parliament with or without amendment and presented to the President, then it is imperative that the President should give his assent. So, you see there are three complications as far as the ordinary bill is concerned. Either he gives his assent just like that without any questioning, but if he thinks that it is not necessary, the bill has to be passed, he can withhold it. The third thing is he can make his amendments and give it for reconsideration to both the houses of the Parliament. But he can also send it for reconsideration and it can be passed by the Parliament and saying that the President has to sign and the President has to give his assent. So, we know that in India the governance system, although there are three separate organs, there is a control mechanism like a checks and balances, so that the majority representation of the people's voice can be heard. And it is not convened by one personal decision of one person. So, it cannot have a veto power for the President, but he can give it back for reconsideration. Now, we have learned about the ordinary bill. Now, we will know the difference between the ordinary bill and a money bill. Money bill cannot be passed in both the houses of Parliament. It is very important that it is passed by the Lok Sabha, the lower house of the Parliament. You can see the constitutional provision for the money bill, and that is why it is very important that the lower house takes an upper hand as far as passing the money bill is concerned. Article 110, that is Article 110 of the Indian Constitution, deals with the definition of money bills, and also it states that a bill is deemed to be a money bill if it contains only provisions dealing with all or any of these matters. Okay? So, what are the matters, what are the important points that needs to be considered as far as a money bill is concerned? We see that the imposition or abolition or remission or alteration or regulation of any tax. Okay. Secondly, the regulation of the borrowing of money by the union government. It is also necessary to see the custody of the Consolidated Fund of India or the Contingency Fund of India, that is the payment of monies into or the withdrawal of money of any kind. Is there a provision for it? Also, the appropriation of money must come out of the Consolidated Fund of India. And fifth point is the declaration of any expenditure charged on the Consolidated Fund of India or increasing the amount of any such expenditure. Then a money bill can come. Also, the receipt of money or the public accounts of India or the custody or the issue of such money or the audit of the accounts of the union or the state can come in the form of a money bill. Any matter incidental to any other matter specified above. Okay? However, a bill is not to be deemed as a money bill basis on the reason that is not provided in the above given list. Okay? So, we see that when a tax is imposed or it has to be removed, then a money bill can come. We also see that if it is in the case of a borrowing or anything to do with the Consolidated Fund of India or anything concerned with the public accounts of India, then you see that the money bill comes into act. Okay, all the receipts, all the audits, all forms comes as a money bill. So, you know that you have to see that the provisions accommodate the money bill. Large scale taxes can be considered as a money bill. So, if any question arises where a bill is a money bill or not, then the decision of the speaker in the Lok Sabha becomes final. It is also imperative that his decision in this regard cannot be questioned in any matter in the court of law or by the House of the Parliament or even the President. So, you see how the speaker becomes very important to consider whether that should be considered, a point has to be considered as a money bill or not. And also, when a money bill is transferred from a Rajya Sabha for recommendation and presented to the President for assent, the speaker endorses it as a money bill. Okay, this endorsement of the speaker is very necessary, and especially when a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President, then the speaker has to endorse that it is a money bill. The Constitution lays down a special provision or a special procedure for passing a money bill in the Parliament, and a money bill can be introduced in the Lok Sabha, and that too on the recommendation of the President only. So, every such bill is considered to be a government bill and it can be introduced by a minister. Now, if you see what is the difference between an ordinary bill and a money bill, you see that it can be introduced either in the Lok Sabha or a Rajya Sabha, as I told, in a ordinary bill considered. Considering the money bill, it can only be introduced in the Lok Sabha and not in the Rajya Sabha. And also it can be introduced either by a minister or by a prime minister as far as the ordinary bill is concerned. Whereas in the case of a money bill, it has to be only introduced by a minister. And also it is to be introduced without the recommendation of the President. But here it can be introduced only on the recommendation of the President. And also in the case of an ordinary bill, it can be amended or rejected by the Rajya Sabha. But in this case of the money bill, it cannot be rejected by the Rajya Sabha. The Rajya Sabha should return the bill with or without recommendation, and it can be accepted or rejected by the Lok Sabha. So, the Lok Sabha in the case of a money bill is shown as very powerful. Also, it can be detained by the Rajya Sabha for a maximum period of 6 months. Whereas, in the case of a money bill, it can be detained by the Rajya Sabha only for 14 days, not for 6 months. and it does not require the certification of the Speaker as far as the ordinary bill is concerned in the Rajya Sabha if it is originated in the Lok Sabha, whereas it requires a certification of the Speaker if it has to be transmitted to the Rajya Sabha. And also it is sent to the President's assent only after being approved by both the houses. In case of a deadlock due to disagreement, then both the houses will have a joint session so that it can be resolved, and it will be summoned only by the President. In the case of the money bill, it is sent for the President's assent even if it is approved by the only Lok Sabha and there is no chance of any disagreement between the two houses. There is no chance of any disagreement between two houses, and hence the provision of joint sitting of both the houses in this regard is not provided. Okay. So, we do not have a joint session as far as the money bill is concerned, because we know that the Lok Sabha is very powerful and it is to be recommended by the President himself. Then the other points are, its defeat in the Lok Sabha may lead to the resignation of the government if it is introduced by the minister as far as the ordinary bill is concerned. What about the money bill? If it is defeated in the Lok Sabha, it leads to the final resignation of the government itself. There is no questions asked. If the failure of the money bill, then the failure of the government. Whereas an ordinary bill, it can be reconsidered for a no confidence motion. And finally, it can be rejected, approved or returned for reconsideration by the President. And in the case of a money bill, it can be rejected or approved, but cannot be returned for reconsideration by the President. So, it can be rejected or it can be approved, but cannot be sent for reconsideration. So, you see how there is a difference between the ordinary bill and the money bill. The finance bill also kind of faces the same procedures, and we need to know why the money bill is given so much of importance, because the money bill has got the provision of the Lok Sabha having the same authority and the power of passing a bill. The President, on the other hand, can accept or reject, but cannot send it for reconsideration. And due reason, you can ask what is the reason why the money bill is so powerful. We have already seen that step by step scrutiny goes around. Considerations are made, and that is why when a money bill is passed, because it involves money, it involves finances, it involves the economy of a country. So, the money bill is very crucial and has to be exerted with lot of care and scrutiny. And so, it has to be justified why such taxation has to be allotted, or some taxes has to be removed. There should be some justification so that a good governance can be practiced. I hope you understood the legislative procedure as far as the ordinary bill and the money bill is concerned. Thank you very much.